Okay, well, good morning, everyone, or good afternoon or good evening, wherever you are. So my name is Max Del Mar, and it's really a great pleasure and delight to welcome you all to this event on Cormac Maksymilian's new book, New Constitutional Horizons Towards a Pluralist Constitutional Theory. Actually, you probably can't see that very well, can you? This is because of my background, but this is a proof which Cormac has kindly shared with us. And we have, Gulch, one of our organizers, is going to, there we are, she's, I think, put a link to the book in the chat, which includes the beautiful cover as well. And I think the book is coming out very soon in physical form, I think towards the end of March. So we're all looking forward to that. So Cormac has been a leading voice on constitutional pluralism, EU law, constitutional theory, human rights for a long time now, and it's a real treat to have the full statement, as it were, of his view in the book, where he shows, I think, very persuasively that pluralist constitutional theory is both viable and important. If I may say so, to me, when reading it, it read as a kind of Dworkinian meta theory, which invited reflection, invited us to reflect on how we do theory, on how we theorize pluralism, how we theorize constitutionalism, and shepherding our views in ways that encourage, might enable productive and genuine disagreement, but also allow us to give practical guidance on particular conflicts between authorities in the transnational and global domain. So it's a great book. I enjoyed it myself hugely. And we're going to hear very soon from Cormac, who will introduce the book. We then also have two commentators. We've unfortunately lost one of them for personal reasons. Nicole Rowan isn't able to join us, but we have two wonderful commentators, both of whom have written extensively on pluralism, authority, conflict in the transnational and global context. First, Roger Cotterrell, who is at Queen Mary, and secondly, Ralf Michaels, who is at the Max Planck in Hamburg and also at Queen Mary. So we're delighted that both of them can be here and to engage with Cormac's book. In terms of the format, I've already mentioned that Cormac will introduce the book, then we will have Ralf and then Roger commenting, Cormac giving a reply, and then there should be plenty of time to ask questions. Feel free to use the chat as we're going along and post questions there. I will monitor that, and if you're unable to ask your question, I can ask it on your behalf later on, or of course you can also ask it yourself. We'll be recording the first part of this, the first part, as it were, where we have Cormac and the two commentators, but won't be recording later, just in case it makes a difference as to whether you ask a question or not. So without any further ado, I'm going to hand over to Cormac now to give us an introduction to his book.
Okay, thank you very much indeed, Max, for your kind comments, but also for putting this together, especially very quickly and very efficiently. Also thanks to even though I don't know what they're going to say, I'm going to thank them in advance, Ralf and Roger, for engaging with the book and just being here, giving up your morning to be here to discuss the book as well, and of course to all of you sitting at home watching this.
Sorry, Cormac, just to interrupt. I think your volume is a bit low.
Yeah, it's very quiet.
Yeah.
Can you hear me now? Is that better?
It's very quiet.
It's very low. Yeah, it's very quiet. If you maybe try and unplug it and plug it back in.
Yeah. Is that better? Can you hear me better?
Only slightly. What about moving it closer? Can you move it closer to you? Or
this is, hold on, let me just
that's a bit better.
Yeah. Can I get to the settings on the...
I think that's better, Cormac. If you have it close to you, that's better.
Yeah, okay. So everyone can hear me okay?
Yeah, this works, yeah.
Great, okay. Apologies for that. All right, so two things to say. First of all, my headphones, which I picked these headphones because I thought they worked better, but it seems they're not. They do belong to my son. They are his computer's headphones, but all the other headphones I tried or mechanism made it sound like I was in a bathroom. So I thought it was more important that you hear me clearly and I look a bit silly rather than using standard headphones and you're not being able to hear me. I'm going to give it just a short presentation of the book. As Max pointed out, publication is imminent, although unfortunately I got an email from OUP just yesterday. The production is a bit stuck, so everything is ready to go and has been for at least over a month now. But they're trying to track down the estate of the artist for the cover art who needs to give the final sign-off for the picture. So unfortunately it's stuck and we're not sure when we get it. It's a picture by Mark Rothko and it's his estate needs to sign off on the cover, I think, and they still haven't managed to do that. So we're hoping that publication is imminent. Everything is ready to go once they give us the okay. But yeah, as of yet, it's unfortunately not available to those of you who haven't received the proof. So I'm sorry about that. Okay, so just going to give particularly for the benefit of those who obviously haven't had prior access to the manuscript, just an overview of what the book's about, what are some of the core things it tries to do. It is, as Max said, my contribution to the idea of constitutional pluralism in a way, and it does this by setting up a sort of an assumption of what it calls the circumstances of constitutional pluralism. The idea here is that constitutional pluralism is ubiquitous in the contemporary world, right? Not just in the way that legal pluralists used to talk about pluralism, normative pluralism, legal pluralism in terms of post-colonial settings, but in the ideas in our everyday lives almost. We encounter some form of legal and constitutional pluralism. And this is, of course, particularly the case if we are officials or judges or trying to do our day-to-day jobs as somehow engaged with or involving the law. So the idea is that there are a number of questions that kind of fall out of this ubiquity, and different people have theorized these questions in different ways, but the way that this book tries to approach them is how do we theorize what it calls the idea of plurality, or what I put here, the circumstances of plurality and the circumstances of pluralism. The idea of plurality, and here I'm borrowing on Nicole Rowan's work, is thinking about a multiplicity of legal norms and legal orders applying to the same subject matter and the same subjects. So how do we try and understand that? How do we theorize that in order to be able to go about the practical work, particularly legal decision making? And also it identifies what it calls the circumstances of pluralism. And this is how do we theorize multiple authority claims at different levels of governance and maybe using different bases for their authority claims. So that's what the kind of backdrop or the assumptions the book makes about the circumstances of pluralism. These are, of course, live questions and have been answered in many different ways by many different authors. What the book tries to do is make a contribution to them to push the debate forward a bit. With regard to the question of how we theorize plurality, that is the idea again of different legal systems applying to the same subject matters and subjects. It works through some of the key questions on this. Just to highlight two of them. One is the idea that if we can conceive of legal plurality, then we must be able to conceive of non-state law, right? Which is something that is often assumed, but it's kind of almost a truism of legal plurality. And it interrogates some of the questions in regard to this using the old example of international law as a kind of paradigm example of non-state law, and tries to use that as a basis then to argue for legal plurality, potentially other forms of non-state laws. It also tries to engage with the question of the individuation of legal systems as well, which is another question that the circumstances of constitutional pluralism throws up. If we assume that the circumstances of constitutional pluralism are a reality of our legal and political world, then this assumes that we have a way of individuating or differentiating between different legal systems, which is, again, it's an assumption about constitutional pluralism, but not one that's often brought to the fore. So that's what the first part of the book tries to do, engaging with these questions of legal or constitutional plurality. It reappraises the debates on the legal nature of international law, so the extent to which international law can be considered a system, arguing that this is a plausible account of international law, going back into those old debates of Hart, Kelson, and others, and also goes into put forward a revised account of how we individuate legal systems, so building on the literature on the individuation of legal systems and analytical legal theory, and provides a revised account of how we can do that. With regard then to the second part of the book, which looks at these kind of multiple authority claims, constitutional authority claims, this part of the book theorizes constitutionalism as a distinct form of authority claim, and argues that it faces the circumstances of constitutional pluralism pose three distinct questions with regard to theorizing constitutional pluralism. The first is an old question, the definitional conundrums that we encounter when we talk about constitutionalism. This isn't, of course, distinct to or particular to discussions of constitutional pluralism, but is of course very relevant to them. And so that the problems that we come across when we say, well, what do we mean by constitutionalism? I mean this, you mean that, and then we end up talking past each other. So how can we engage with the idea of constitutionalism as a normative theory of authority in a substantive way, rather than engaging in, well, talking past each other, what Ronald Dworkin, of course, famously called a semantic sting. We're just arguing about semantics. The second question we encounter when we talk about constitutionalism as a normative theory of authority is the question of the backlash, or at least those who don't accept that constitutionalism, so I have to be careful what I say, but don't necessarily accept the authority claims that attach themselves to constitutionalism. And here we go into the debates about the associations between constitutionalism and entrenchment, the associations between constitutionalism and judicial supremacy, and the familiar democratic critiques of this idea that we come across in constitutional debates. Again, it's not one that's specific to constitutional pluralism, and I don't want to claim that, but it is, of course, very relevant to constitutional pluralism as well. The final question is relevant to constitutional pluralism, and this is the idea of non-translatability, to use that metaphor, or we can talk about metaphors of exportation, or using constitutional language discourse in non-state settings. So this parallels or mirrors the question of law outside the state. Here we're talking about constitutionalism as an authority claim outside of the state, and this brings us to what is better usually known as the no demos thesis, so that there's no demos, say, at the transnational level or at the international level. So talking about constitutionalism in this context is a category error. So the second part of the book then tries to address these questions with one arrow, as it were, which might be a bit too ambitious, but that's something we can discuss. And it does this by taking this was the meta-theoretical approach that Max referred to, which I think most of us are familiar with, this idea of Dworkin's approach to interpretive concepts. And it says that we can address these familiar critiques of the idea of constitutionalism and transnational constitutionalism if we adopt this interpretive approach to constitutionalism as an interpretive concept, or if we treat constitutionalism as an interpretive concept. This helps us overcome the definitional conundrums that we encounter when we consider constitutionalism and normative theory, because it argues that the definitional conundrums stem from treating the concept of constitutionalism as a criterial concept rather than an interpretive concept. It also helps with the charge of illegitimacy, because the interpretive approach to political value, as Dworkin has expanded upon in his work, inexorably in a way leads to this idea of the unity of value. This is, of course, what he exposed most thoroughly in his final work, Justice for Hedgehogs. And so if we take this holistic approach, then we can sidestep at least some of the critiques of constitutionalism as being anti-democratic or somehow illegitimate, by saying that we must strive to interconnect our best interpretations of the political value of constitutionalism, so we don't end up with these lopsided or disaggregated forms of constitutionalism which are popularly used, particularly at the transnational level. And finally, the non-translatability question in Chapter 7, I argue that at root this is a question, or the charge is about the charge of idealization, that trying to use constitutional discourse and constitutional language at the transnational or international level is a form of critique of ideal theory, and that provided that we manage this carefully and we talk about it in terms of de facto authorities, this isn't a problem, or it's certainly not fatal to thinking about the idea of transnational constitutionalism or international constitutionalism. It does also suggest that idealization isn't necessarily in itself a problem, provided that we're clear about what the purpose of our theorizing is, and that this that whatever normative theories that we produce out of this factor in the purpose of the theory in the context within which we're talking about. So, to summarize, it just tries to break apart this atom of constitutionalism or constitutional things, and tries to really put a kind of a magnifying glass on some of the core questions and assumptions that we make when we talk about constitutional pluralism. I don't want to suggest, just in the structure of the book, that it's divided into the first part is legality and the second part of legitimacy, the idea of a legal system and the questions attached to that, and the idea of constitutionalism as a normative authority claim and the questions that attach to that. I don't want to suggest that they are mutually exclusive. And the points in the book, I do recognize that they are interconnected. I definitely don't want to go into debates about the is and the ought and inclusive and exclusive positivism and all of that kind of stuff. But I do think that this parsing out of our two different senses of constitution and constitutionalism is helpful to help us isolate what specific questions attach to each of those issues, to be able to work through those problems and maybe make a little bit of progress in understanding both the challenges that the circumstances of constitutional pluralism present for our received theories of legal systems and constitutionalism as an authority claim, and also maybe make a little bit of progress in how we can develop and innovate in those theories to better reflect and address the issues that the circumstances of constitutional pluralism pose. So I think I'll leave it there, and yeah, I look forward to the comments and questions. Thanks.
That's great. Thanks a lot, Cormac. So Ralf?
Thanks. I figured I should virtually applaud first. Thanks very much for allowing me to be part of this and for commenting on this book, which I really enjoyed. Cormac, congratulations on the book. I'm not sure why you chose Rothko, because especially if it's difficult. But it's a really,
I wish I hadn't now, but yeah.
Yeah, it does look nice when it comes out. It's a really beautiful book. It's extremely clearly written. It's extremely accessible, insightful, nuanced, and yet constructive. So it's really kind of a book in the best way that helps us understand, helps clarify things. I really enjoyed it. I was very glad I could read it, and slightly jealous because I wish I had written that book, or at least a book like it, and maybe I will if I live long enough. I want to really address only one point, and the point that makes me feel a bit like a one-trick pony, and I apologize for that. I want to bring in the perspective of the private international law scholar. And I want to do that because I feel that many of the problems that fortunately come to the fore in current legal theory in general, and in particular in discussions of legal pluralism, are problems that find their practical equivalence or are mirrored doctrinally, if you want, in private international law. And it seems to me that many jurisprudential approaches would benefit greatly from that perspective in addition. I think that would also be true for Cormac, although I must admit my own fault for that, because Cormac sent me an article some almost 9 months ago, and I begged forgiveness that I didn't get to answering, and then I never answered. And so it's entirely my fault, really, that this is not in the book. But I'll try to address what the conundrum is that Cormac has here, and why it might actually not be as pressing as he makes it. So the project he describes as, interestingly, very early in the book, I quote here, the circumstances of constitutional pluralism are made up of the background conditions which inform our understanding of the world as it is, which set the conditions for our theorizing. It's a very complex sentence, right? And in the whole book, actually, Cormac, while he's very clear, he does not make things simpler than they actually are. But you can see that this goes, oscillates a little between, if you want, an ontological claim, a constructivist theoretical claim, and a normative theory. The normative theory that is mostly described in the, I'd say, in the second half of the book is one that arises from conceptions of justice from Hume to Waldron, and is really translated into a normative concept of constitutionalism and of constitutional pluralism. The ontological issue there, the background condition, which I take to be ontological conditions, are the observance of a plurality of laws or plurality of constitutions, and what is later called the world-state gap. It is the lack, if you want, of a world state. I'll come back to that. So we have multiple laws, multiple constitutions, with no one state to bind them all and find them in the dark, or whatever the quote is. So it is actually plural in that sense, whereas the normative claim, which is based on constitutionalism, comes from theories that are monist in the broader sense, that is, that emerge from being within legal systems. And the theoretical tools also come from theories that are monist in the broader sense, that they, by and large, more recently emerged from the state. That's one thing that Cormac addresses, and it's an interesting part, I think, in the book. He asks, to what extent does legal theory have a plurality problem, by which he means, to some extent, to what extent is it so bound up with the state and the state paradigm that it cannot truly account for both, I would say, the possibility of non-state law and the problem of interaction of laws and legal systems. And in the chapter, I think it's chapter 2 in the book, he says, actually, the problem is not so great. The broad concept that all law is state law is not one that is really defended by almost anyone, certainly not by Kelsen, and I think he's right about that. The weaker claim that state law remains the paradigm is one that seems stronger but not insurmountable. And the yet weaker claim that, I'm pulling this up here, that legal theory in general has neglected non-state law, that seems to him partly accurate, but not really a big problem, because legal theory can look to that as well. And that becomes for Cormac a defense to use effectively theoretical tools that are more or less borrowed from the concept of legal theory that have been developed within the state concept, but are not necessarily bound to that. I'm looking for the quote, I'm not finding the exact quote. That's interesting. I think he's right. I think he's right to say that in a world that is ours, in which legal theory has developed its concept in view of states, and in view of this proximity between state and law, then these are the tools that we have, and that we need to use also when we move beyond the state and beyond the idea of one state. That is, it would not make sense to have an analytical theory that develops concepts out of thin air without any relation to the real world. And it seems somewhat unsatisfactory to have approaches, I think Tamana is mentioned in there, that give up attempts of conceptual clarity and basically just describe whatever someone calls law and makes law. So in that sense, I think he's absolutely right to use that. At the same time, I think that this creates limits to him, or he thinks it creates limits to him, that he then has to overcome with a Tolkienian political conception. I think it's on that state, at that step, that I think he does not use all the tools that he has, that he could use. In other words, his choice of these conceptual tools that are to some extent linked to the state is narrower than it would have to be. And even state originating or state related or loosely state correlating tools in legal theory would have helped him with the problem. Let me try to show that in the context of chapter 4 in particular, which is the chapter that looks at interaction between legal systems. What Cormac is concerned about is that he says traditional theories of law that are based on validity and on recognition all become ultimately monist systems. That is, as long as we have some the grounding of validity, then external norms, rules external to the legal system are always at some point through validation, through linking through to a basic norm or a rule of recognition or something, they're tied into the legal system. Through recognition, they are brought within the one legal system. So true plurality cannot be accounted for in that way. This is already there in the Kelsen-Hart distinction. And this, he says, cannot account for problems in which we think of legal rules as both valid and external to one legal system. Problem that Joseph Raz addresses. I'll quote at some length here from the beginning of chapter 4. The circumstances of constitutional pluralism also present us with the fact that not only do multiple legal systems coexist at different levels, but that they also overlap, interact, and potentially conflict. This feature of the circumstances of constitutional pluralism raises a further puzzle for our pluralist constitutional theory. In what way do legal systems interact, and how do we theorize this interaction? That is, how should we understand the increasingly common phenomenon under the circumstances of constitutional pluralism, whereby the courts of one legal system self-consciously recognize and apply the norms of another external system, such as, for example, when the courts of a state apply the norms of a transnational legal system, or when the courts of a transnational legal system apply the norms of general public international law. So that is the problem, if you want, of norms that are considered both valid and external to the legal system. That is, a legal system, say a state legal system, says certain rules of transnational law are valid, and not only that, I'm going to apply them, but they are not part of the legal system. We do not want to fall into the trap of drawing all of that in that sense. And now Cormac's interesting suggestion is really to move away from questions of validity and recognition and to move to ideas of political reasons. So he said this is a conflict. This is not a conflict between legal systems, he says. Characterizing such conflicts as conflicts between legal systems presupposes an Archimedean vantage point from which such conflicts can be approached, and that does not exist. And I think he's absolutely right on that. Let me call that the Archimedean problem in this. And then his solution is to say, in fact, this is not a conflict between legal systems, it's a conflict within the system. It's a conflict within the system between the claim to supremacy and the claim to openness. Legal system wants to claim supremacy, that is, it wants its own rules to govern, to determine what is right and what's wrong. And it wants to be open to other systems. It wants to be open to defer to others, even where their respective normative claims are different ones. Now, this is familiar from a conflict of laws perspective. In fact, it almost describes at heart what the problem in private international law is between the application of the lex fori and the application of the lex causae, where lex fori is the law of the court's own legal system, and lex causae is the foreign legal system. So it's basically in the formulation of the private international law rule, do we apply our own law or do we apply foreign law? in fact, formulated as a legal question within the legal system, not more political than other legal questions would be. If you translate that into politics or into justice, we discuss in private international law the discussion between substantive justice and conflicts justice. Substantive justice being justice in the substantive sense, what is right and wrong for the people before me. Conflicts justice as being justice towards other legal systems, that is, from a conflicts perspective in a world of multiple legal systems, just allocation of regulating powers between these systems. So in that sense, if you want, we have the philosophical equivalent to this discussion in conflict of laws. But that only addresses the first part of the problem, that is, do we apply our own law or the foreign law? That is an internal issue for the legal system. This is the domestic private international law rule. It does not explain or account for the second step, which is the actual application then of the foreign law. Because the foreign law as such in the conflict of laws process remains foreign. It becomes applied in the legal system, it remains foreign. There have been attempts to resolve this as well and to say the foreign law is actually not applied, but what we do is we create our own rule within our own legal system that just mirrors perfectly the foreign rule. We call it the local law theory. David Cabers addressed that idea already, I think, some 90 years ago in a nice quip that I'm going to quote here. Theory that explained how it is that a foreign rule isn't foreign law when it is used in deciding a case in another country might seem more useful if I could forget the way in which my son resolved a like problem when, at the age of 4, he encountered tuna fish salad. Isn't that chicken, he inquired after the first bite. Told that no, indeed it was fish, he restored his world to order and concluded the matter by remarking to himself, fish made of chicken. So that's really the idea of translating the foreign into the domestic by claiming that it's something new. But the reality is that what we apply is actually foreign law in private international law. And so I think that second point is not fully addressed by Cormac's suggestion, which remains only in the question, do we apply our own law or the foreign, but not accounts actually for the foreignness. Now, his challenge here is that he says there's no Archimedean point. Now I come to his first point, from which this conflict could be resolved in anything other than this political way in which one legal system determines its relation to the other legal system. So either I place that at the top and become monist, or I have some external umbrella that somehow allocates these in the way in which European Union conflicts rules allocate between individual legal systems. And that seems not right to me. That's where the second point comes in. And this now draws for 1 minute at least on recent work that I've done and rules of external recognition. There is no Archimedean point, or you could say there are two Archimedean points. There is the relation between, say, to use a simple example, the relation between, say, the law of New York and the law of California is determined as not one conflict, but two conflicts. It is one conflict from the perspective of New York law, and it is one conflict from the perspective of California law. So Cormac is right to say, to call this one legal conflict requires an Archimedean point. But he's wrong to say, for that reason, it can't be a conflict, because in reality, it's two conflicts. There are two systems that both take this internal decision on when to assume their supremacy and when to have their openness to the other legal system. And they can come to different conclusions. So in that sense, the true challenge, I think, in this constitutional pluralism is that not that we don't have one Archimedean point and therefore have none, but that we have very many, that the entire world is conceptualized from multiple perspectives, that the universe in that sense is a pluriverse. And so my legal theoretical suggestion is that this, in fact, is part of the legal theory array of state law. That is, conflicts rules, private international law rules that actually apply foreign law while maintaining their otherness, that I call rules of external recognition, are part of that state-born array of legal tools and would have been available, or should be available, to theories of constitutional pluralism. That's, if you want, the legal theoretical jurisprudential suggestion that Cormac creates, in a sense, a problem as very hard that is less hard on the basis of this two array. I'll also make a plea for the political attractiveness of this system. Because of course, and Cormac addresses that at length, problems of justice always face the issue of pluralism, of normative pluralism, of different conceptions of justice, and of course, different local, geographical, societal conceptions of justice that interact. The desire, the Dworkinian desire for integrity, for integral justice conceptions is laudable, but always has to remain local. That is, it can always be within, say, Scottish law to say, we determine on grounds of justice to what extent we apply our own law, to what extent we defer to foreign law. It remains local. The idea of a universal justice that transcends this plurality seems to undermine the very normative ideas of constitutional pluralism. And so the attractiveness of this suggestion of interaction, in my case through rules of external recognition, is that it can account also for the normative aspect of pluriversality and the normative actual pluralism of justice conceptions that have to interact. Because each system builds its own view of also its relation of self and other, but that interacts with the other societies, the other systems' perspectives on self and other. And so this remains anti-foundational in the sense that it does not ultimately resolve these conflicts, something that is a practical reality, as we know, and is not in this sense a theoretical impossibility because of this multitude then of perspectives. So that's, if you want, my smuggling myself into Cormac's project to say, first, there would be analytical tools that could resolve the problem of plurality and interaction that I think would ease some of the problems. And second, normatively, from a pluralistic theories of justice, the step into Dworkin and of ultimate ideas of conceptions is too short because it does not sufficiently account for this true pluralism. And I mentioned this as a very friendly critique or as a way of thinking this forward. And I think I've spoken too long anyway. I'll stop there. Thank you.
That was great. Thanks a lot, Ralf. Never going to be able to think of tuna in the same way again. Roger. You're muted, Roger. You're muted.
Okay. Okay. You can hear me now. Can you hear me now?
Yes, yes, yeah.
Okay, sorry about that. Well, first of all, I just want to echo what Ralf has said about the quality of the book. I accepted Max's invitation to talk about Cormac's book because I have a kind of oblique interest in constitutionalism. That's to say, I'm very ambivalent about constitutionalism, and I wanted to try and clarify my ambivalence. And Cormac's book does it brilliantly because, as has been said, it's such a rich discussion of so many aspects of constitutionalism. And what he does specifically for me is to really argue very, very powerfully for the integrity of the idea and the way it can be used. And he's doing that with a recognition that, as he puts it, there's so much cacophony. There are so many people who talk past each other as constitutional critics because they can't even agree on the basic terms in which they're debating. And Dworkin's semantic sting operates all the time. So my single point really is to talk about the problems of using the concept of constitutionalism, which of course is very, very central to the book. I'm not going to talk here about pluralism very much, although I've written a paper which does have a lot to say about it. But I knew Ralf would have plenty to say about pluralism, so I've left that to one side. I just want to talk about the idea of constitutionalism. And in particular, Cormac's extremely interesting discussion in his chapter 6 and then his chapter 8 about what he calls the critics who are are kind of skeptical about constitutionalism because they see the idea of constitutionalism and the practice of constitutionalism being used for what he calls malign ends. So I get to that in a moment. Why am I so ambivalent about constitutionalism? Why did I need Cormac's book to try and help me with this so much? I have a confession to make. When I was many years ago, when I was an undergraduate student, I was a really starry-eyed constitutionalist. I admired the US Constitutional Court immensely because it was coming to the end of Earl Warren's time as Chief Justice. And the US Constitutional Court, its leading judges seemed to be judges who were both principal political actors and powerful judges. And they seemed to be moving America forward in ways that I liked. And very soon after that, I began to realize that this was a blip, this was an aberration. Actually, constitutional interpretation, at least in this particular constitutional setting, was very often not about progress, in my view, but about reaction. It could switch very easily from one to the other. And I took eventually two lessons from my kind of disillusionment about the US Supreme Court. One was that constitutions are ultimately about people, those who can declare the meaning of constitutional principle and provisions, far more than about abstract principle. And secondly, that the larger and wider the fundamental values that a constitution is thought to proclaim, the more arbitrary and unpredictable their interpretation can be. So I kind of ended up as some kind of legal realist in relation to constitutionalism. Cormac's book is extremely helpful and encouraging to me because he is also very clear about the ambivalence of the idea of constitutionalism and the way that it is so often, it kind of disintegrates in a way into conversations which cannot really be productive. So it contains, a constitution normally contains very precise rules or relatively clear rules, and also very large values and large principles. Part of it is usually to do with regulating and controlling government and setting limits to government, and part of it is about enabling government to operate. And as the book makes clear, there are two ways of handling this dilemma. One is, as some critics have suggested, disaggregating the idea of constitutional principle and constitutionalism so that different aspects of constitutional practice operate in different contexts for different reasons. The other way, which is the way that he favors, and which is what I want to talk about mainly, is the Dworkinian route. It would be rather easy to kind of spend this few minutes talking about Dworkin rather than Cormac, which I don't want to do. But nevertheless, Dworkin, I think, as I read his book, provides the route by which Cormac escapes from these terrible dilemmas about finding a route, finding an integrity to the idea of constitutionalism. So I need to say a little bit, a kind of reaction to these ideas. Putting things very simply, Dworkin gives us a strategy of three parts in interpretive practice. One is to ask those involved in interpretive practice to agree on basic historical facts about a constitution which they're going to interpret. The second is to find agreement on the point or purpose of the constitution, of having a constitution, the ultimate purpose or point of it. And on the basis of that very minimal agreement, which leaves many things open plainly, they can then go on to the third stage, which is to disagree, or which is to have many different interpretations of constitutional principle. The key thing is that the idea of constitutionalism hangs together because however much disagreement there is, and there's bound to be an awful lot, there are still basic structures within which that disagreement takes place, an understanding of what constitutions are about, and an understanding of the historical circumstances in which a particular constitution has come to be. And so this is a very persuasive and very useful way of, as Cormac says, avoiding the kind of definitional questions. We can work out what constitutionalism means through an interpretive process which is coherent in itself. And of course, it's closely related to Dworkin's original idea of the right answer thesis. In judicial interpretation in hard cases, there ought to be the assumption that if you worked hard enough and you were smart enough and insightful enough, you could find a right answer. In fact, you never would, but the important thing was to assume that there was one. And the important thing with Dworkin's, the application of Dworkin to constitutional interpretation is that there is a way of getting a best reading, a best working out of ultimate constitutional purpose. Interpreters should all be engaged in that process. And what about those who aren't engaged in it, those who don't believe in it? Well, of course, they're the external skeptics, Dworkinian external skeptics. They deny, in this context, they deny the possibility of any objective truth about the nature of constitutionalism. So what about me? Where do I stand? I'm sort of an external skeptic up to a point, and my kind of disillusionment about the US Supreme Court made me a legal realist, or sympathetic to legal realism in the context of constitutionalism. But I want to first of all take issue with Dworkin's internal-external skeptic division, or the division between internal interpreters and external skeptics about the very idea of constitutionalism. Certainly not all legal realists could be easily categorized as internal skeptics or internal interpreters or external skeptics. For example, Carl Llewellyn, who undoubtedly believed in interpretation, but didn't believe in it in the way that, in the sort of way that Dworkin would accept. Many who are very concerned with normative interpretation are also observers of the very process they're engaged in. You could say they're external observers. They move between an internal perspective and an external perspective all the time. Lawyers who interpret are also observers of the practice in which they're engaged in, and that observation feeds into their interpretation. And similarly, external observers, like sociologists who want to understand legal processes, don't normally get really into depth in that observation unless they can turn themselves into interpreters and understand the way interpretation happens. So my sort of preliminary point is that I'm a bit unsure about the sharp divide between internal and external in this context. So moving rapidly on to the main thing that I wanted to talk about, the second half of Cormac's book is concerned with constitutionalism as a normative matter, in which the purpose really of constitutionalism is to work out the conditions of legitimacy of government, to work out how government can be legitimate, how it can be accepted as such. He rightly says that the first part of the book and the second part of the book are closely linked, the first part being concerned with the descriptive aspects of constitutions, the second part concerned with the normative aspects. But it seems to be that ultimately the second part of the book is the most important. This is the part which shows the integrity, the potential integrity of the idea of constitutionalism. And that integrity is centered on the possibility of making governments legitimate, recognized as legitimate. So just before I sort of leave Dworkin and Cormac's use of Dworkin, I'll just emphasize the point that Cormac emphasizes in the book, that the process of trying to find the best interpretation of constitutional values in order to find out how to recognize legitimate governing authority, that process is not one of compromise between political values. It's one of continual reasoning to try to understand better, to collectively read a constitution in the best way. You could say this is a take it or leave it theory. You either accept this way of doing things or you don't. And my suspicion in the end is that Dworkin's divide between the internal and the external is ultimately a divide between those who accept the Dworkinian method of interpretation and those who don't, or those who see it as less pure, if you like, more complicated, more messy, harder to define. And I put myself in the latter category. Compromise, I think that the problem I would have with Cormac's use of Dworkin to give the idea of constitutionalism real integrity through interpretation, is that it doesn't seem to recognize that compromise is what it's all about. It's not, we have to believe that there is a possibility of working towards a best reading, a best interpretation. We have to believe that, that conscientious interpreters will do this. They will recognize that they're in a common project of seeking the best meaning, going about that. And from a realist perspective, one can sort of question whether that is actually what goes on. I think I'm probably too influenced by my 50 years of reading of the US Supreme Court and its interpretation of the Constitution, but it seems to me that over and over again, what you see is not judges, constitutional interpreters seeking the best reading of the Constitution. What you see is political actors who are basically organizing their political action around constitutional provisions. If we recognize that constitutional interpretation and constitutional practice is very much a matter of compromises, then we could look at a jurisprudential practice, a juristic practice, which recognizes that, takes it on board and works with it. And in recent years, my favorite conception of juristic practice in that way is Gustav Radbruch's, the German legal philosopher Radbruch, who saw as central to juristic practice the negotiation of basically three values, which are often incompatible with each other, but somehow have to be balanced, somehow have to be worked out in their interaction in particular contexts, at particular times, in particular places. For Radbruch, they were the values of justice, security, and what he called fitness for purpose in a cultural context. I interpret that third value to really mean seeking solidarity in modern conditions, justice, security, and solidarity. And Radbruch's claim is that there are no answers. There are no timeless. There's no timeless unity of value which could be sought. There's no ultimate reconciliation of these values. They're always in tension, and all that can be done really is for the jurist to engage in producing a compromise of values which works at the time, in the time and place, works in that circumstance, not for a moment imagining that it's going to be permanent or that it's going to have any timely significance. It's it's a compromise for the time and place. So juristically, in constitutional interpretation, I would find it more helpful, in a way, more plausible to see the practice that's going on as one of compromising in constitutional language many clashes of interests which the jurist or the constitutional interpreter tries to relate to each other in a way that produces peace, and even perhaps consensus for the moment. It's not a best reading, it's not a best interpretation of anything. It's a pragmatic compromise of values. I think I probably just have maybe 2 or 3 minutes left. I just want to say a word about the idea of legitimacy, which is so crucial to Cormac's book in its second part. The idea of constitutionalism is ultimately, as a normative project, about producing legitimacy and showing how legitimacy can operate through constitutions. And most legal and political philosophy, of course, devotes a huge amount of time to explaining the nature of legitimacy. I think ultimately what lies behind most of that analysis is the assumption that legitimacy involves the acceptability to the governed, to the regulated population, of the actions of those who govern them. It's about acceptability to the governed in some way. Again, from a realist perspective, you could say this surely has to be ultimately an empirical question, a sociological question. Why is it that people do accept certain things, certain systems, certain constitutional structures as legitimate? Unfortunately, there is a very large amount of empirical research on that very question, especially by writers such as Tom Tyler in the United States and others who worked with him. The conclusion of much of it is that legitimacy, the acceptance of procedures as legitimate, depends on perceptions of their fairness. Fairness is the key thing, and it's what people think of as fairness. Have they been fairly treated? Do they feel that the system they've been involved with is one that recognizes them as having concerns and interests of their own and takes account of those concerns? In a constitutional context, you could say that the most important procedures, which have to be seen as fair in that kind of sense, are those that govern democracy. And because those procedures, democratic procedures, promise the best possibilities for all citizens to assert their political demand for equal respect for their individual autonomy and dignity. So in that sense, perhaps legal philosophy and empirical socio-legal research agree that fairness is a key thing, and that democracy is ultimately the key value underpinning constitutionalism. But to get finally to the question of malign ends, Cormac points out that critics of constitutionalism often point out that it can be used, constitutionalism as an idea and constitutional structures can often be used against democracy to control the popular will, to limit the realization of electoral wishes. And this is done, of course, through constitutional arrangements for judicial review, especially judicial review of legislation, and through the entrenchment of clauses, which he writes about, especially in the EU context, the interpretation of EU treaties by the judiciary and constitutional arrangements within the EU, which is essentially are aimed at something like ordoliberal purposes, entrenching certain especially economic situations as unalterable by popular vote. I tried to find what I thought would be really convincing answers to these criticisms in Cormac's book, but I find, to my great dismay, however much I admire his arguments, that ultimately the arguments come down to the same thing: more reading, better interpretation, more conversation between the interpreters, again the search for some unity of values, some best interpretation of the Constitution and the constitutional structures. So I'm still left with a worry about all this, and I think that kind of forces me to say that alongside jurisprudential approaches, we have to recognize that politics often trumps the jurisprudential approaches. You see that today with the US Supreme Court, the blatantly partisan appointments to the US Supreme Court, in my view, blatantly partisan judgments which come out of it. This is constitutional interpretation, but unfortunately it doesn't look anything like the idealist and extremely attractive normative interpretation which Cormac's advocating and which he suggests is often undertaken. So I remain a reluctant skeptic about constitutionalism, but that doesn't alter the fact that the book is incredibly rich. It illuminates so much. It really pursues an argument about the integrity of constitutionalism as far as it can possibly go. And for that reason, it is something which is a very, very valuable read. And I'm privileged to have had the opportunity to read it and think about it. Thank you.
Well, thank you hugely to both Ralf and Roger for these, I think, wonderfully rich remarks. Cormac, you have an option now to say a few words. I know it's going to be difficult to be comprehensive in terms of an answer, but to give you an opportunity to say a few words by way of response.
Yeah, just a few words. You can hear me okay? Yeah, good. So my one real disappointment, especially after hearing these great comments, is that we're not together in the same room. I mean, this sounds like the kind of thing that would be just lovely to sit and talk about and take somewhere else afterwards. And the tyranny of Zoom and everything, it's just, I just really felt overwhelming disappointment that we are not in the same room to discuss this. But thank you both so much for engaging, for taking it seriously, and for sharing your compliments. It was very appreciated, but also your doubts and your worries and your skepticisms. I couldn't, as Max said, do justice to all of them, but just to pick up perhaps a few threads. So to start with, Ralf, so just to go directly to this point, I don't take the second step, right, of actual application of foreign law, and these are not fully addressed. Accounting for the foreignness, I think, as you put it. You're right. I don't do that, and that is something I need to think about. For me, this taps into the question of, I mean, I think we're all grappling with, I think, right, when we talk about legal systems interacting in some way, about how to engage with the externality, with the foreignness, without collapsing into monism. And that's partly what that chapter is trying to do, right? The kind of monist manner, as it calls it, just because it's alliterative. I don't really like the label monist manner, but anyway. You know, and there's lots of different examples of this and lots of different ways people have tried to do this, and interface norms. And I was listening to Jeremy Waldron-Storr's lectures on the podcast a couple of weeks ago, and his, use Gentium as a similar kind of attempt. How do we understand engagement with legal systems without collapsing into monism? And it's an extremely difficult thing to do. So I suppose what I would say is, to kind of extrapolate a bit on what I've done in the book, right? So first of all, I try and point out, look, they're not legal, they're not necessarily purely jurisprudential questions. They are political reasons that resonate beyond the legal system itself. They also bring in its political and social context. And this is Raz's point about, legal systems operate in political and social contexts, and we must take that seriously. And it's not to say that courts, to tap in a little bit to Roger's comments, can't make political decisions or don't take political decisions into account. I think they do. But I think it's useful, first of all, to identify what kind of reasons they are, right, for discriminating between internal and external. And these are political reasons, as I suggest, relating to supremacy and openness. The private international viewpoint, you're absolutely right. I'm not a private international lawyer. I think that's quite obvious. I'm a public lawyer. Most of my examples come from teaching and reading interactions between EU law and state law, and also, of course, the German Constitutional Court, right? And the puzzle is going to, how do they know that this is an external norm? Was this question that just kept coming back to me and wouldn't leave me alone. And it was really looking at that kind of interactions that I came up with this framework in order to be able to identify what kinds of reasons they are. I think it might also work for private international law, and I think you might agree, Ralf. I don't think you were denying the fact that this doesn't necessarily. In fact, I think you said this is what private international has been doing, and if that's the case, then that's great. Then we're on the same page with that. I guess, to answer the how do we know the foreigners question, then I would say, well, it has something to do with those political reasons. That would be my kind of short answer. It has to have something to do with the political reasons that courts discriminate between different norms as internal and external. I know that doesn't get us much further, but I think that's the beginning of an answer, to say that the way we account for that is to say, well, these are, to what extent do we want to, and this taps into your point about justice as well. You talked about conflicts justice and substantive justice. I think these touch on that, right? These political reasons about supremacy and openness touch upon these questions as well. So that's the beginning of an answer. I would say they're still political reasons and they're still relevant. It doesn't completely account for foreigners, and I need to think about it a bit more, and I need to look at a lot more private international law, but that would be the beginning of my answer to that point. So the two perspectives, the one perspective, two perspectives. Yes, I mean, this goes back to the same question about how do we account for this liminality, if you want to call it that, but that kind of space between legal systems without collapsing into monism. What I did think about when you were talking about it is it depends on whose perspective, right? From the viewpoint of the court, is it really two perspectives? So does the California court really, is it possible, right, to split itself in and take on the perspective also of the New York court, right? Is that possible? Which is one question. The other one is, okay, but from the viewpoint of the theorist, and then we run into this problem. As theorists, we probably can take an Archimedean viewpoint, but then the question is, of course, what's our methodology for theorizing law and legal officials, right? The internal point of view, recognition-based accounts of law, and so on. There are questions that emerge out of that. Again, I would say that maybe, and I kind of hint towards this in that chapter, but I don't expand on it. You're right, and maybe that's another paper. But to say that the court may take into account what the other forum will think about their decision, right? And this will impact upon its decision and how it thinks about it. And maybe therein lies the two perspective point that you're talking about. The question then remains to be seen, what does that look like, right? If we say, can that court take a two perspective view by maybe thinking about it in terms of what would be the consequences of this judgment and what would an external audience think about it? And maybe there's the beginning of a two perspective view that doesn't involve some sort of schizophrenic, I'm a New York court and a California court. I'm a California court, but I also care about what New York courts might think about this decision, right? Which again, I would suggest, given the approach I take, would be political reasons, but and again, I would say it's this balance between supremacy and openness, but I wonder whether I would call that a two perspective view. I wonder if it's, there's something in here about recognition. I know you've written about this and other people, and this is something I've been thinking about, recognition in general, what it looks like, and you know, to what extent this translates well to these types of questions. But so yeah, maybe if the two perspective view, I would be on board with if it was something along those lines about thinking about the impacts of your decisions on external judicial actors, rather than saying I can be a New York court and a California court, right? I don't think that's jurisprudentially feasible. Yeah, so that's just initial thoughts off the top of my head to those specific questions. Roger, this is really illuminating, really rich. Thank you very much. Where do I start with this? So just to go to the external skepticism point, right? So what I was trying to do here was kind of outline a general methodological approach, right? Whether that involves constitutional interpretation or not, right? Of course, Dworkin talks about constitutional interpretation in Law's Empire, but that's one chapter, right, of the whole book. And the methodological approach is outlined in chapter 2. And the way I understand it is to be like a general methodology of interpreting political value, right? Whoever we are, wherever we find ourselves, friends in a pub discussing the rights and wrongs of sanctions against Russia or whatever else it is, right? It doesn't have to be restricted to textualism, constitutional interpretation. And that was how I interpreted his writings. And if we look at his later work on, you know, Objectivity and the Truth, You Better Believe It, and all that kind of stuff, he kind of leaves courts behind a bit and starts talking just more generally about how we inquire into normative values, whoever we are and wherever we find ourselves. And that was very much the kind of spirit in which I was following his approach. Not being, I know it is confusing because I do talk about the whole book about constitutionalism, but it didn't, and there is that part in chapter 8 where I say, this is a solution to the specific questions that relate to constitutional interpretation in the case of constitutional pluralism. But I was trying to be a bit more ecumenical about it and saying, look, whoever we are, wherever we find ourselves, this is perhaps a fruitful way of thinking through questions and theorizing disagreement about specific contexts like questions of constitutionalism, questions of transnational constitutionalism, whether we're judges or not, right? So I didn't want to limit it to issues of constitutional interpretation. If we broaden it to that extent, then I would suggest that even legal realists are internal skeptics, I would suggest, right? Because they are, and this is, you know, Dworkin's broader point about internal and external skepticism, they do believe in value, right? In some sense, most of them, as I understand, right? Some sort of value. They think courts get it wrong and judges aren't the best way to do it and all of that, but they use values to critique judges and courts and all of, and the law, right? And that is for Dworkin in this much broader sense, as I understand him, a form of internal skepticism. The external skepticism, the person who just, look, there's just no such thing as value. There's just no point. We're just emoting. This is just, it's a bit kind of nihilistic, right? It doesn't really matter what we do because normative values, political value doesn't exist outside of our own subjective preferences. There's no reality, no truth to it. And that's not how I would read a lot of, although I will confess that it has been a while since I've read Llewellyn and others, but I understand a lot of what they're doing is to say, no, look, you're promoting the wrong values here, right? You're relying on the wrong kinds of value here. Don't expect to get to that value by looking at courts, or don't put faith in judges to get things right according to that particular value or that particular ideal that we hold, right? Whether it be justice or something else. And that, for Dworkin, in that more general sense, would be a form of internal skepticism, relying on value to denigrate value, right? And so that, my response would be then, I think legal realism is in a form, depending on our legal realism, right? But we could read a lot of legal realism as a form of internal skepticism on that view. So I have so many notes. I'm just trying to scroll through to see. The point about legitimacy, this is something we all struggle. I've been struggling with legitimacy for a long time. Even though, so I've come to the position, so I like Weberian legitimacy, legitimitates Glaube, right? I think for me it's become sort of Normativitätsglaube, and Ralph's just going to punish me now at my terrible German, but the idea is a belief in normativity, right? That for me is what legitimacy really core is. It's not just a belief in a given governing authority and we go along with the reasons. It's a belief that normativity matters, and that has it has explanatory value in the way that you say this is why the people believe that a particular authority is legitimate, but it is at root a normative discourse, I think, for me. It has to have, and it's that old Durkheimian idea, right? Beyond coercion and self-interest, there is a space there that we observe where people defer to an authority for normative reasons, right? That are not because they're afraid that they will get shot or whatever it is, right? And once we start talking in those terms, I think we're already sort of on the road to where I want to be in terms of what I'm trying to do here. You suggest I overstated, and I think that's a fair critique. And there are lots of parts of this chapter that I myself am not completely clear on, whether I stand over all of it, and there are things I need to think through. But I think once we already enter the norms, the universe somehow of some what we could call Normativitätsglaube, maybe there's a hook there in that we can work a bit more on, right, in the idea of normativity. And I think maybe you might agree with me on this when you talked about fairness. I mean, fairness has to have normative implications, right? I mean, and democracy has normative implications. So we're already in the coming closer, I think, and there's some sort of ballpark there. How we do that and whether courts can do it and through constitutional interpretation, of course, that doesn't answer that particular question, but it does bring us away from some sort of what kind of solipsism, right? Nothing succeeds like success. Legitimacy is what it is, right? And gives us some purchase to try and think through some of these. What does fairness mean? What does democracy mean? What are these normative questions? In a very quick kind of defense of, and like, I'm not even sure whether I can defend Dworkin to the hill, because I don't go into all the kind of Dworkin literature in this, right? I instrumentalize Dworkin to my own ends, and I realize there's a whole swathe of literature critiquing Dworkin that I haven't engaged with. And I think you're right to kind of highlight this. I do have a sense, though. So what I like about it is to say, okay, compromise, value, conflicts, these questions. To me, I was, I'm a kind of, I suppose my background's in Millian liberalism, sort of Rawlsian liberalism. Yeah, okay, that's intuitively correct. And then I think Dworkin is right to press us, but how does that make any sense, right? We need to be somehow on the same page when we're talking about values and normativity and so on. And if it's just about value conflicts, and I believe in, rule of law, and you believe in democracy, and this doesn't make sense of what we're trying to do, and I don't think it necessarily makes progress on important questions in trying to understand what makes things legitimate. And that's why I was attracted to this idea that just kept coming since I read Dworkin sort of as, during my PhD, and I'm trying to make sense of what he was talking about. It took me an awful long time to understand his interpretative method. I'm not even sure I've got it right, but there's something I find very attractive about this making sense of a disagreement, in normative questions that I find. He's one of the few people who directly engage with that and tries to make sense of it in some way. And for that alone, I think it's worth pursuing his project when we're talking about disagreement in this sense. Maybe not all the way, and maybe, what I do in this paper, I mean, maybe not entirely convincing, and say, look, I'm just trying to do it in the context of constitutionalism and the particular types of questions that emerge in relation to transnational constitutionalism. Dworkin wants it to be about everything, right? About morality, aesthetics, ethics, everything under the sun. I'm trying to be much more kind of parsimonious and trying to limit it a lot more. I'm not sure whether I can do that, get away with that, because Dworkin's theory is ambitious. And I think once you start down the road, you kind of end up down there. But I would just try and rescue a little bit of Dworkin, say, look, this, it does make, there are questions there, even if we talk about value conflicts, compromise, and so on, that can't just be, well, you won and I lost, right? I believed in one thing, you believed in the other, and the way that the chips fell where you won and I lost. And I think there's something to that. There has to be some sort of overarching coherence to what we're doing if we're really disagreeing. And that's something I think I like about Dworkin, about his methodology, but I do need to do more work on. Sorry, I've already talked too long and I know we're running out of time, so I'll stop there. Thank you.
No, that's great. Thanks, Cormac. I think at this point, Gul, we should stop the recording.